like Greg, I think that this is a question that reasonable minds can disagree about, and it pains me somewhat. Actually, it doesn't pain me really, but to have to disagree with Greg when we often agree on so many issues. But in this one, I think he's given you an analysis that doesn't persuade. From my mind, framing the issue is critical. So I think some preliminary observations before I talk about law are in order. First, the resolution says unconstitutional and illegal. I'm not going to hang my hat on the and, that is, you have to find at both to agree with Greg. But it does speak to law, which was the first question asked by one of the people in the audience. This isn't about whether or not you think it's a good policy or a bad policy for BART to do things as it did. It's about that reasonable minds can disagree far more, and there's much to be said on either side. But I want to focus this on the question of legality to some degree. Second, the resolution speaks to government agencies. Interestingly, I don't think this would be a question at all if BART were a private company, right? At least certainly not on a constitutional level. The legal issues do apply to common carriers, but as a constitutional matter, the First Amendment speaks to acts by Congress and has been extended by judicial action to governments, other government agencies. It doesn't regulate private citizens or private companies in the same way and to the same degree. I'm skipping a lot about how it does regulate private citizens, but it's important to know that we're focusing here on what government agencies do. But most critically, from my position here, the resolution says, absent a declared national emergency. Now that's a pretty darn narrow realm in which Greg and those who would support the position would accept government-sponsored cell phone and internet blackouts. In effect, it states the contrary position in the affirmative, that the only reason and the only time a government may lawfully act, government agency may lawfully act, is in the case of a declared national emergency. Or to put it another way, in the resolution's judgment, all forms of limitation or regulation under the terms of the resolution are impermissible unless there is a national emergency or a declared national emergency. And so I think that my colleague must defend an almost indefensible proposition that the government is constrained from acting in all other cases than ones in which a declared national emergency exists. By this, I take it to mean a national emergency as in a war, a civil insurrection, possibly, if you accept federal emergency management emergency declarations as declared national emergencies, natural disasters like an earthquake in San Francisco or another Hurricane Katrina, but not in any other circumstance, right? That can't possibly be right. Leave aside the law for a second and simply deploy common sense. Here's a couple of hypotheticals. Terrorists intend to blow up BART in a tunnel underneath the San Francisco Bay. We think that the trigger is a cell phone trigger, right? And BART wants to turn off cell phones in the BART system to prevent the bomb from exploding and the tunnel underneath the San Francisco Bay from imploding with water. Under the theory espoused by the resolution, we are powerless. However horrific the planned attack, it isn't a national emergency, much less a declared one. Instead, it just really sucks to be San Francisco, right? They'll just have to suck it up, since it would be impermissible for BART to turn off the cell phones for this reason, even if it would save lives, right? Yes, okay, maybe that's an easy case, but let's go to the other end and ask, how about this rule? What if BART, or Amtrak, has a quiet car? And to enforce the quiet car, they actually just turn off the cell phone service in the car. Nobody, I would suspect, thinks that Amtrak or BART are violating the Fourth Amendment by enforcing a cell phone-free zone in a quiet car traveling up to New York. Now, maybe you think that's just a debater's trick, right? Finding some good examples. And to some degree, I admit it is. That's what debates are all about. But I actually think that posing these hypotheticals are critical to decision-making about the proposed resolution. Context matters. The resolution is grounded on the experience in BART where a limited shutdown for safety was instituted to frustrate a proposed protest. So the question isn't whether or not we are going to travel all the way down the road to where the president can commandeer the internet and shut it down for all time. And permitting government action in limited safety circumstances to provide for the security of the citizens is not really, in my judgment, the first step on a slippery slope to China's Great Firewall. Indeed, if I can wax philosophical for a minute before turning to the law, I think the key difference between where I sit on this issue and where Greg does is I think we can draw lines. And Greg fears that we can't, that if we permit limited intrusions of this sort, we'll run all the way down to censorship. So let me turn from philosophy then to law. And unlike Greg, I think that we're in the wrong place here. I don't think that this is a CSPRI issue at all. I don't think that cyber is really that different from any other form of protest, and I don't think that the forums are changed by the nature of the means by which the protest is communicated. I will accept Greg's challenge, right? I could stand this argument on the idea that public transit is a non-public forum, and there's a great Supreme Court case on it, which is pretty much on all fours. You have to make the move from the transit, right, to the airwaves. But that's a bit like saying that the inside of the bus is transit, but the outside where the ads were is different as well, because that's not the same as the transit modality inside. And I don't think that that's a convincing argument. I think that BART can stand on the proposition that we're not obliged to take all the speech that comes our way. But let's actually ask, what's the analysis if this is a public forum? If this is a public forum like a park? I was surprised that Greg didn't mention the leading case on that, a case called Clark versus CCNV, the Community for Creative Nonviolence. It's from 1984, and it involved a case where a bunch of protesters wanted to sleep on the mall as a form of protest and gathering, shades of Occupy Wall Street today. But this is actually why, in the legal realm, Occupy Wall Street is mostly losing its cases, right? The court agreed at the first instance that sleeping in the park to protest was a form of free speech. And for our purposes, we can say that gathering in BART to protest is a form of free speech as well, and be perfectly happy with that. But the court said the government had a substantial interest at stake. And it wasn't safety, though that would have been, an easy one for me. It was something far less significant, in my judgment, maintaining the beauty and hygiene of the national parks, right? And the court said, so long as the restrictions on the protest activity were reasonably related to that goal, and they were because it wasn't a prohibition on all protests, it was a prohibition on sleeping in the park with tents. And so long as the restrictions were applied in a content-neutral manner, that is, so long as the government applied those restrictions to all protesters alike and didn't pick and choose between the people whose voices it liked and the people whose voices it didn't like, then the government restrictions, commonly called time, place, and manner restrictions, were in fact constitutional. Greg's opposition to what BART did assumed, I think, a fact that is not in evidence, namely that it made the decision to shut down the cell phones and attempt to frustrate the protest because it was speech, and I wrote this down, with which it disagreed. Now that may have been a case at some level, since they were protesting some BART activity in the context, but there's no evidence at all that BART would not similarly frustrate protests with which it agreed, or with which its members of its board agreed, if it likewise thought that they were a danger to the safety and the safe operation of the BART system. How am I doing on time, boss?
You've got
5 minutes. Oh, I'll be finished before then. Content neutral means having clear rules in advance, ex ante, and applying them to all people one way or the other. I mean, the question that is raised, for example, in the Occupy Wall Street cases is not whether you favor their message, but whether or not in applying the law, the cities around the country are content neutral, and they would expel evict, that's the word I was looking, evict anybody who camped in the parks for, you know, greater than a couple of days and began to pose hygiene and safety risks. Here, I think we begin with the assumption that we take BART at its word, that it was doing what it did in order to frustrate the protesters because of safety concerns, that it would do so regardless of the message involved, and if so, the restrictions are at least constitutionally okay. There's a draft BART policy that they made in response to these events, in which they said that they would apply their limitations when there is, quote, strong evidence of imminent unlawful activity that threatens to harm passengers, employees, transit property, or cause a substantial disruption of train service. I read nothing in that that says, and we don't like what they're saying. And taking them at their word, that is a reasonable time, place, and manner restriction. Indeed, I would say that the construction here is far narrower than BART actually needed to do, because at least under Community for Creative Nonviolence, they could include issues like beauty and hygiene, right? So they could frustrate graffiti artists just as readily, if that were the aim. But they haven't done that. They've limited themselves, a policy decision, not a legal decision, to some imminent unlawful activity that threatens actual harm. Now, Greg has talked briefly about the Communications Act statutes. I confess I'm less of an expert on that than I would like, so I'm going to have to defer somewhat to him. But I do understand that all of those acts have public safety exceptions to them. I can't say much more than that, because in truth I am less well versed in that than I would like to be for a debate like this, but I couldn't learn communications law just to play in the forum. And if need be, I'll go back to unconstitutional and illegal and win that way. But surely it cannot be the case that BART can't turn off the cell phone bomb trigger because it hasn't had time to go get an order from the Public Utility Commission of California. I would submit to you in closing that this issue is really much greater than the question of cell phones. And I take the opposite perspective from Greg. Time, place, and manner restrictions are, I think, core understandings of how we measure free speech and also the opportunity to maintain good order and good governance. They lie at the core of noise limitations on protesters who are prohibited from exercising their free speech rights in residential areas after 11 p.m. They lie at the core of restrictions on anti-abortion protesters who must stay back from abortion clinics a certain distance in order not to frustrate other people's rights to go inside. They stand at the core, ultimately, of all of the heckler cases, which are the cases where speech is being heckled by somebody also exercising their free speech rights to disagree with the speaker, but there's a reasonable time, place, and manner restriction on the ability of the heckler to interfere with the ability of the speaker to give the speech that he was presumably invited to give. If you stand for the proposition that time, place, and manner restrictions are unconstitutional, you stand for the proposition that there's no capacity for government to maintain good order, whether it's in the hypotheticals I've posed or in the actual case involved that we're here to debate. I would submit that BART's activity was perfectly lawful, that it was intended solely to insist upon maintaining the safety of the system, and that there's no real evidence in the record that I know of to the contrary. I would take them at their word. If it turns out in the end that they're going to let all the pro-BART protesters in, but none of the anti-BART protesters, we'd have a different case. And if we had that case, I'd be on Greg's side. But so long as government makes reasonable time, place, and manner restrictions that are intended to foster public safety and does so in a content-neutral manner, the Supreme Court says that's okay.